All right, let's talk about SB 43. This is probably the biggest shakeup to California's conservatorship laws in decades. And if you're an attorney who's going to be arguing these cases, whether you're county counsel, a DA, or a public defender, this is for you. The entire playbook is about to change, and you've got to be ready.
And hey, this isn't some abstract thing happening somewhere else. Right here in Merced County, the clock is officially ticking. This all goes into effect on January 1st, 2026. So let's get into exactly what you need to know to prepare.
So here's our game plan for today. First, we're going to get right to the heart of it, the new definition of gravely disabled. Then, we'll see how that changes the rules inside the courtroom itself. We'll run through a hypothetical case to see it in action, touch on the big constitutional fights that are brewing, and then wrap it all up with a tactical playbook for both sides of the courtroom.
Okay, let's dive right in. The absolute core of SB 43, the thing you have to understand inside and out, is its new definition of gravely disabled. Honestly, every other change, every new strategy, it all flows from this right here.
For years, we all knew the standard: food, clothing, and shelter. It was concrete. Well, SB 43 just blew that wide open. Now we're adding severe substance use disorders into the mix, and these new, much more subjective concepts of personal safety and necessary medical care. This shift, this is where all the new legal battles are going to be fought. So what's really interesting is how this new definition completely changes the game inside the courtroom. This is where you're going to find new openings for your arguments and, let's be honest, some brand new challenges, no matter which side you're on. Okay, this is a big one. There's a new hearsay exception. The court can now look at statements made for medical diagnosis or treatment directly from the records themselves. You can see how this is an absolute game changer for how expert testimony gets presented, and as we're about to see, it cuts both ways.
If you're on the prosecution side, you're probably thinking, great, this makes things so much more efficient. But if you're a public defender, I'm sure the alarm bells are going off. This raises some serious due process questions. I mean, how do you cross-examine a note in a chart? It really puts a limit on your ability to confront the actual person who made the statement. Now, beyond just the evidence, SB 43 puts a brand new mandate on the table. The court must, and that's the key word, must, now explicitly consider less restrictive alternatives. You know, this has always been kind of best practice, but now it's the law. The law is forcing the court to admit that, yes, conservatorship really is the nuclear option.
So the main takeaway here is that this whole debate about alternatives is no longer a footnote. It's not a side conversation anymore. It is now a central battleground, and you have to be ready to fight on that ground in every single one of these cases.
Okay, theory is one thing, but let's make this real. We're going to walk through a hypothetical case to see how all these new rules are actually going to clash in a real courtroom. Because trust me, a file that looks just like this is going to land on your desk very soon. So meet John. He's 45, and his situation is basically a perfect storm of all the issues SB 43 was written for. He's got a severe opioid use disorder, co-occurring depression, he's neglecting his diabetes, and he's malnourished. Now, under the old law, the fact that he finds intermittent shelter, that might have been enough for the defense to win the case. But now this becomes the million-dollar question for the court. Is John gravely disabled under this new, much broader definition? And you know what? There's no easy answer here. It's all going to come down to how you, as the attorney, frame the evidence and tell the story.
And here's where you can really see the conflict. The DA is going to hammer on that necessary medical care and personal safety language. They'll say his inability to manage his diabetes is a textbook example. But the public defender, they're going to push back hard, arguing, look, these are bad choices, but they are his choices. And then they'll pivot right to demanding that less restrictive options be tried first. So, zooming out from a single case like John's, you can see that SB 43 opens up some really big constitutional and ethical cans of worms. These are the issues that are going to be debated in appellate courts for years to come. The most obvious constitutional challenge is going to be void for vagueness. Defense attorneys are going to argue, probably successfully in some cases, that a term like personal safety is so subjective that it's basically meaningless. I mean, what does that really mean? And who gets to decide? Can you really take away someone's freedom based on a standard that's impossible to pin down?
And that ties right into these other huge concerns. The classic battle between individual liberty and state intervention, the very real worry that this law could disproportionately impact marginalized communities, and of course, the giant elephant in the room. Do our counties even have the beds and services to make this law work in the first place?
So, with all of that swirling around, let's get practical. Let's boil this all down into a tactical playbook you can start thinking about for your day-to-day practice. Okay, for the prosecutors in the room, your new playbook is all about being thorough and getting ahead of the arguments. You have to build an ironclad case with incredibly detailed evaluations. Document every single instance of medical neglect or risk. And don't wait for the defense to bring up alternatives. Address them head on and prove why they are not viable options. Now, for the public defenders, your strategy is going to be a multi-front attack. First, you hammer the vagueness of the statute at every single opportunity. Second, you have to become an absolute expert on less restrictive alternatives so you can present a real, compelling plan to the court. And finally, you start laying the groundwork for an appeal by raising those big constitutional issues early and often. In the end, this is really the fundamental tension of the entire law. On the one hand, you have a tool that's designed to protect some of the most vulnerable people in our community. And on the other hand, you have a tool that dramatically expands the government's power to take away a person's freedom. As you get ready to navigate all these changes, just know you're not going it alone. Here are some key local resources right here in Merced County that can offer support and give you a lot more detailed information. Ultimately, this law leaves us with a profound question, and it's a question that's being placed directly in your hands. On a case-by-case, person-by-person basis, you are going to be the ones in the courtroom arguing the answer. Where do we draw the line between helping someone and controlling them?